Back with two cases to hear with this panel. Judge Greer has exited, and we are pleased to welcome Senior Judge Tom Bauer to join us today on this panel for two cases, 24-1675, State of Iowa versus Martel Guider, and the second case we'll hear today is 250556, FS Inc. versus Jefferson County Conservation Board. So arguing on behalf of Mr. Guider today is Melinda Nye, and on behalf of the state is Lois Sloven. So Ms. Nye, when you're ready.
Good afternoon. May it please the court, counsel. Martel Guider appeals his conviction for exploitation of a minor. He's raised three issues on appeal, including a challenge to the sufficiency of the evidence supporting his conviction and a challenge to the imposition of the 25-year sentence that it constitutes cruel and unusual punishment as applied to him. We've also raised a third issue challenging the lack of a knowledge element and the district court's refusal to instruct the jury on that, but because that requires overturning Iowa Supreme Court precedent in State versus Gilmore, I wasn't planning on addressing that because the court can't do that, unfortunately. In this case, the evidence presented at trial was insufficient to support Guider's conviction pursuant to Iowa Code Section 728.12 sub 1. Guider was charged and convicted with the production form of exploitation. So that meant the state had to prove that he solicited, knowingly permitted, or caused JW to engage in a prohibited sexual act, and that he knew or had reason to know or intended that it would be photographed or filmed.
In this case, there was a jury, and there was testimony on both sides. Are you, as part of your argument, asking us to substitute our fact-finding for that of a jury?
No, in this case, it's just, ultimately, it's a failure of the state to get in the required elements. And part of that is the crux of this crime is in the asking, and it's not enough that he asked for a nude photo or that she sent a nude photo. The crux is he had to either ask her to create a new nude photo. The crux of the offense is asking her to engage in a sexual prohibited act, which includes nudity. So ultimately he had to ask her to engage in nudity knowing or intending it be photographed, or he had to have caused her to actually do that, to engage in nudity and take the picture. That's an awkward phrasing, but that's, and so the state handled the questioning. I mean, she was asked the sum of the evidence on this. We know a nude photo was sent, naked buttocks photo was sent, and she sent it to him. And we know her testimony was that she was asked in direct leading question, did he ask you to send him a nude photo? Yes. And did you send him a nude photo? Yes. But that's not the question. Did she send him a nude photo? It's did she take one? Did she create a photo for him by engaging in, purposely posing nude and taking the photo? And the state, every time they talked about it, how old were you when you sent the picture? Is this the picture you sent? Did he ask you to send a picture? That's different than the actual crime under 728.12.1 is, did he ask you to create a photo? Did he ask you to pose nude and take a picture of it? Or did he cause you to pose nude and take a photo of it? And it's just ultimately, there could have been, ideally, I think the state, there could have been a follow-up. She clearly sent the nude photo. The follow-up question would be, and did you take it because he asked you to? Did you, there's follow-up questions that could have sealed those gaps in the record, but the gaps just simply weren't sealed in this case.
Distinguish that from the State versus Sharon case, which was the Iowa Supreme Court case, I think from 2003, that says the crime is in the asking. So under that case, did the state need to prove that she took the picture after he asked?
I don't remember the specific facts of that case, but the crime is in the asking, but it's in, you have to ask for the right thing. You have to ask for the prohibited act, which is posing nude and taking the photo. And so a simple blanket, I'd like to see nude photos, or can you send me nude photos, is not sufficient. In this case, like I said, because we know there was a photo, if it was true that she took a new one at his request, that should have been asked. That needed to be tightened down. And so it's just, ultimately, there's nothing to make that inference on. The state had complete control of this witness. They controlled the questioning, and they just simply, assuming that evidence existed, didn't get that evidence into the record, the correct evidence. I guess I'll turn to the cruel and unusual punishment, unless there's more questions about that. It's sort of it's a simple argument, and there just really isn't anything there. There isn't enough to make to go beyond conjecture and speculation that she did actually create a new photo for him. Under the cruel and unusual punishment test, under both Iowa and the U.S. Constitution, the test is the same. And the first step is to establish a threshold test, which is when you look at the facts, with an as-applied challenge, you look at the facts and the situation here, and look at then the punishment that's been imposed, and you balance the gravity of the crime with the severity of the sentence. And you can tell from 728.12.1, it covers a wide range of behavior from consensual romantic, people in a consensual, legal, romantic relationship exchanging, nude or explicit images, to the forcible abuse of children while taking a video, and so Guider's conduct is clearly at the less culpable, less harmful range of that conduct.
Would that be why he was given a suspended sentence as opposed to being
Yes, we hope so. Yes, and I recognize that's that's important here. He was given a suspended sentence, but it's still that 25-year sentence with a mandatory minimum is still hanging out there. And if he would violate and have that probation revoked, that's excessive with the facts in his case.
There's no question the district court judge imposed a sentence that was permitted by the statute, correct?
That's correct.
So is that not a legislative change rather than something our court can do?
Because we're alleging it's cruel and unusual punishment, it is something that the appellate courts can address. The exact remedy we've proposed, I know the Supreme Court's, in Louiselle, and has really struggled with how to do that when, there isn't necessarily a separate punishment alternative that, which of course there isn't, or the judge wouldn't have had to impose that. But, we've suggested as a remedy that the mandatory minimum could be severed. That's an easy way to sever. That was, part of Louiselle. And the other alternative is, as the state proposed in Louiselle, to sort of move down the spectrum of other exploitation counts or other crimes that this could fall under, and impose a sentence that was more in line. For example, solicitation of a minor is a Class D felony. So there's other, there's other options for a remand, yeah.
Clarification question. You indicated you're not going to be arguing about the requirement for knowledge of a minor's age because of our court's ability to change precedent. Are you waiving that argument on appeal?
I'm not waiving it. It's just I recognize that this court can't overturn State versus Gilmore, and that's what is required for us to win on that issue. So yeah, no, I'm not definitely not waiving. Yeah. I guess if there are other questions, I can. Yeah.
Challenging the lifetime special sentence.
That has been determined to be collateral in some ways, but it's part of the whole package of his sentence, which is the 25 years and the lifetime. And so I think that's part of the cruel and unusual punishment. It factors into that, but I recognize there's other that they've tried to say that that's collateral. I disagree, but yeah. Mm-hmm. Yeah. All right, thanks.
Thank you. Mr. Sloven, when you're ready.
Thank you, Your Honor, and may it please the court, counsel. Good afternoon. It's a privilege to be here. Just for clarification, our position on the lifetime special sentence is not that it's collateral or that it is non-punitive. It's just not ripe for a cruel and unusual punishment challenge at this juncture. I want to talk specifically about the sufficiency of the evidence. Our brief doesn't argue caused because opposing counsel is right that there wasn't a question asked to establish causation, that the pictures were taken, right? We don't have that question asked. What we do have is the request itself. And Judge Schumacher, as you pointed out, Sheeran says the crime is in the asking. That's how solicitation works. And I also think that you're on the right track to ask, is this challenge asking us to substitute our judgment for the jury's? And I think it is in how the request is interpreted and understood. That a person receiving that request, as J.W. did, and as Guider would have intended it to be understood, was a solicitation to take a nude photo. That now, now there isn't any conversation in this record about, an existing nude photo, a fact that would allow you to treat this as a request for a photo that already existed. It's going to rely on the jury's common sense and lived experiences in some ways about how to supply the context and also the facts as provided by the witness to supply the understanding of that solicitation. I kind of go back to what Judge Buller said in his special concurrence in Lee about how courts, and there's no record in that case about what the profane term that was used in that case actually meant. It's about courts being aware of the cultural backdrop and the shifting use of language and the way that people use language to communicate. And this request to send a nude picture, at best for the defendant, can be understood as a solicitation for a picture and take one if necessary. And already there, I think that satisfies the definition of solicit them to pose and then take a picture. The posing is the sexual act. Taking the picture satisfies the other element. There's also
Knew that it was sent via Snapchat, right? And there was some text language indicating she was at work when she took the photo, at least in the language of the photo.
Yeah, the caption on the photo itself indicated that she was at work. There's also images in that photo showing the camera roll, showing the pictures, and this is Mr. Guider's camera roll, his saved pictures, showing pictures of her in clothing. And this is, there's no response in the reply brief to what we point out about the escalating series of requests, suggesting that he knew, or at least understood, that his requests were being fulfilled by pictures that were made to order. And even, I am sensitive to the allegation that I am, as one case recently said, willfully violating the appellate rules is what it said when you cite to a source outside the record for a fact that provides background for how to understand a claim. Now, I think that this is something that courts do a lot, and we kind of learn it from reading opinions that cite extrajudicial sources in Crawl, right? Some of the sources that I'm supplying are straight from this court's opinion in State versus Crawl. But the reason this happens is because jurors are supplying their common sense and lived experiences. And we are writing a brief to explain what those what inferences they are drawing from that. And we are citing sources to, kind of paint a picture of observable reality in which these jurors exist. So now, not to say that we don't need to prove our case and put sufficient evidence in the record. We do, obviously we do. And if you want a record citation for where the operation of Snapchat is proven and described, the fact that it automatically deletes messages, that's in volume 2 of the transcript, page 58. It's also described on page 60. This is something that defense counsel argues to the jury as a reason why you shouldn't infer nefarious or sexual motivation from the fact that he screenshotted the photo. He argues that at page 101 and 102. So the jury, the fact that Snapchat automatically deletes photos and videos after they are sent and viewed, this is in the record. This is not something that you need to treat as an adjudicative fact from beyond the scope of the record. I agree with opposing counsel that it's really not relevant. Like, we don't have to answer the question, are the kids all right? Or, do most teenagers have nudes saved on their phone? The real question here is about this solicitation, how it was intended and how it was intended to be received, and what it was intended to mean to the person who received it. And I think that a jury could reasonably find that it was intended as a request to take a nude photo, especially given the reasons that he gave her for why he wanted it, reasons about closer connection with her. That implies a certain degree of authorship and intimacy involved in the act of taking the photo that would become meaningful to him. At best for the defendant, you could get to a reading of this as send an existing nude if you have one. If you don't, take one. And that's a solicitation to perform the prohibited act, the exhibition of the nude buttocks or genital area, and then document it. And he knew that it would be documented when done, and that's a violation of the statute. Beyond solicit, the other alternative that we're arguing is knowingly permit. And I think that only gets one paragraph in our brief, and that's one of my regrets is that I should have dwelled more on it, because I think it only got one paragraph because I think it's easier, and it required fewer words for me to make the case. But he's explaining to her why he wants a nude photo of her, and then he accepts the nude photo that he gets, and the explanation ceases. Or at least there's no testimony that he, and the point of this is that the explanation, him stating the reasons for wanting the nude photo itself is knowingly permitting her to satisfy the request by exhibiting and then documenting and taking the photo and sending it to him. And this is knowingly permitting the exercise of, or the performance of that sexual act and documentation of it. So I agree that there, in retrospect, and this is kind of one of my gripes with sufficiency of the evidence not requiring error preservation, in retrospect, you can now see this theory and say, oh, on direct examination, we should have asked a question like, did you take the photo after receiving the message? Even without that, even without proof of timeline to establish the caused element, the request itself and the explanation that we get within a juror's lived experience and understanding of what that request means, they could make the finding that this was a solicitation to take a nude photo. And I think they could find that based on the reasons he said he wanted it, that it was a request to take a new one to create that connection. But even if not, the fact that the request could be satisfied by taking one if necessary is itself soliciting her to take a nude photo. If there are any questions about the sufficiency argument, I can answer those. Otherwise, I can spend my last bit of time on the cruel and unusual punishment challenge. Cruel and unusual punishment is, the inference of gross disproportionality is a very high bar, a tough threshold to cross. On these facts, it's not met. We talk in the brief about how the short timeline on this is not really so mitigating, it's actually aggravating. It shows a more manipulative process to create a kind of speed run a relationship to get to the point where this request would be treated as something that the victim would grant. And then the use of that photo to defend himself against the victim after he asked for the photo, I think imbues the entire episode with cruelty, I'd say. Now,
Speed run you refer to, this all happened within a month of their meeting to the photo?
Yeah, and I think it's a little fuzzy whether it's 3 weeks or a month, but definitely under a month. The other thing I'd say, and I know the reply brief says that we're focusing on acquitted conduct, and I don't think that that's what we're doing. We're using the facts as testified to by the witnesses, right? Regardless of whether you think an element of a different charge was proven, the witness testifies that he sends the nude photo in order to try to show that she was the aggressor, right? Regardless of whether there's an intent to annoy or injure, her testimony stands that that's the reason he said why he was sending it. And so I think it's fair to consider that in the analysis. And it's, I'm sorry, my time's about to expire. I got one more sentence. Thank you. It's a legislative determination that this needed to be elevated from a Class C felony to a Class B felony. As a policy matter, this court defers to the legislature unless it finds an inference of gross disproportionality, a severe mismatch between the gravity of the offense and the severity of the punishment. And given that the sentence was suspended, can't find that here. Thank you.
Rebuttal when you're ready.
Thank you. Let's see. Ultimately, we don't know whether she took a new photo. And so the knowingly caused or permitted her to do that can't be established. The proof was only that she sent a nude photo.
Counsel's argument with regard to the jury's ability to make whatever inference that they have or do make based on their life experiences and
Definitely. The evidence, sort of what is in the record about, so this is what, if we had the context, and that's definitely what the state wants to argue is this context, and there could be context that would make enough the request of send me a nude photo to meet the elements of this statute. But we don't know the context in this case. The state didn't let her tell her own story. The state gave her leading questions and she answered them. And so the state had complete control of this narrative and just ultimately failed to ask the right questions, again, assuming the right answers were there. And so without this context, we don't know when this conversation, they talked at work, in person, and they talked on Snapchat. We don't know where the request came from. The only evidence in the record about how Snapchat, even assuming the conversation happened on Snapchat, the picture was sent via Snapchat, but they were having, separate lines of communication. And so the only evidence in the record is that Snapchat deletes after 24 hours. We don't know how she used it. We don't know, there's nothing in the record about, do you have to take a new photo? Is it normal to take a new photo? How, and ultimately how other people use Snapchat or how it's even normally functions doesn't tell what she did in this case and how it happened. So we don't know the context of the request because they're having multiple conversations. There's this flirtation is developing, and there's some questions about does he know how old you are? When did he know that? That kind of thing. But it's unclear. I know we're not going to have, because Snapchat deletes, that's the one thing we know, we're not going to have, if it happened in Snapchat, we can't see what the request actually was. Maybe the request was way worse than we don't know, but the state has to establish that. And the state, again, controlled the entire questioning here and just simply failed to get the adequate evidence into the record. And so it's not about, there has to be a basis to make this sort of inference. And if we knew more about the context of the request, then it might be suitable to make that jump to assume that means he's, asking for a new nude photo for her to post. I would contend any nude photo is going to encourage someone to feel closer to the person they're viewing. I don't think that necessarily, that's not such that it requires a new nude photo. And evidence about, what normal teenagers do, it's not in our record and it's not relevant. What matters is what happened in this case. And that this is, again, it's a Class B felony, 25 years in prison. And so it matters, sorry.
Place any significance on the text she included with the letter that was on the exhibit?
Yeah, I was going to mention that. We don't know. There's no discussion of that in the record. You can read it. And is that because she's sending it to him when he's at work? Is it about her being at work? It's not clear. And you can't see. All you can see are, is a bottom. You don't know where she is. And so there's not testimony about that. And as far as the camera roll below, there was no testimony about what that is and if those images are images of her. Her testimony was he just talked about wanting to see her. He liked the clothes she was wearing. He would comment if they were tight, the clothes she wore to work, and he liked that. So it's not clear that he was asking that he'd already gotten photos of her in tight clothes and he was asking for more photos. Now I want naked photos. It's just, he says, her testimony is he liked seeing me in tight clothes, and then eventually asked for a nude photo. And so, let's see. Yeah, that's just, we just don't know the context. And so if this had happened after a discussion where she said, I don't do nudes, and he's like, send me a nude, obviously he would have meant for her to create a new one. And without that context, without that extra, it's not about, it really is, it's pure conjecture and beyond just supplanting the jury's determination. So for those reasons, we would ask that the court vacate his conviction and remand for dismissal, and in the alternative, remand for further proceedings on cruel and unusual punishment. Thank you.
Thank you to both counsel for your helpful arguments today and your briefing. We will consider case 24-1675 fully submitted and will issue an opinion as soon as possible.